Hello and welcome everybody to today's presentation, which is our year in review webinar covering the highlights of Canadian trademark law in 2024. My name is Kwan and I'm a principal in the trademarks group here in the beautiful city of Vancouver, BC. It's my pleasure to introduce our speakers for today's webinar. Today we have Pelle Berends, an associate in our Ottawa office, Tierney Deluzio, a senior associate in our Toronto office, and Meika Ellis, an associate in our Ottawa office. Now, before we get into the substance of our presentation today, I just wanted to say a few words about our firm. Sorry, I missed moving the slides there. Now everyone can see our presenters today. And yeah, just a few words about our firm. At Smart & Biggar, we specialize in intellectual property and technology law. It's all we do, but we'd like to think that we're pretty good at it. We're Canada's leading IP firm with expertise in all areas of IP, whether it's trademarks, patents, copyright, trade secrets, designs, you name it. We do it, and we do it pretty well. Our firm has been around for over 130 years, and our team of now over 180 lawyers, agents, and consultants file over 10,000 patent and trademark applications each year. And not only that, we also excel when it comes to IP litigation, racking up victories for our clients year in and year out. And with that out of the way, we're thrilled to be sharing our insights with you today. Before we dive into the content, though, I just wanted to cover a couple of housekeeping issues. So our formal presentation today will go for about 40-45 minutes or so, and will be followed by an open and interactive question and answer session, where we'll address any specific questions you may have. You're welcome to submit questions at any time during the presentation by clicking on the Q&A panel, which is at the bottom of your screen. We'll try to address as many questions as possible during our live session today. This webinar is being recorded. After the session, you will receive an email with a link to the recording, along with a PDF copy of the slides. And finally, at the end of the webinar, a survey link will pop up. We'd really appreciate it if you could take a moment and share your feedback with us on today's session, and let us know what other topics you're interested in learning about in the future. Oops, sorry, wrong slide. Now we'll just take a look on this slide at the key topics we're covering today. So as you can see, we're going to be covering 5 cases of interest, followed by a discussion of some of the interesting developments in Canadian trademark practice, which took place last year. And so without further ado, I'll turn it over to Pelle to discuss our first case today.
Thanks, Kwan. The first case I'll be speaking about today is Promotion in Motion Inc. v. Hershey Chocolate and Confectionery. This case is interesting because it provides us with a bit of guidance on how to design internet surveys when trying to determine a likelihood of confusion. I will provide a brief caveat. This case is currently under appeal, so the guidance it provides us may be limited depending on how that appeal proceeds. Next slide, please. By way of background, Promotion in Motion Inc., PIM, applied to register the trademarks Swiss Kiss, the word mark, and Swiss Kiss design mark, in association with chocolates of Swiss origin. Hershey, the American chocolate company, successfully opposed, and the Trademarks Opposition Board found that there was a likelihood of confusion with Hershey's Kiss and Kisses trademarks that they had registered in association with chocolate candy. Subsequently, the PIM's applications for Swiss Kiss were refused. Next slide, please. PIM appealed and argued that the board erred in its confusion analysis. Both parties filed substantial new evidence, but for the purposes of this discussion, I'm going to focus mainly on the survey evidence that they both filed to determine consumer confusion and the perceptions of the source of the various trademarks. So PIM filed the 2 internet-based online surveys by Corbin and Bork, they're 2 experts, and Hershey filed the Mulvey affidavit, which was written by their expert, one of their experts, to identify certain design flaws in the Corbin and Bork surveys. And then Hershey also filed the Brigley survey, which was designed using many of the same features as the Corbin and Bork surveys, However, it was designed without those design flaws to show what the results would have been without the design flaws. Next slide, please. Speaking to the survey evidence specifically, Pim, as I mentioned, filed the Corbin and Bork surveys. Corbin's survey dealt with the Swiss Kiss design, while Bork's dealt with the Swiss Kiss wordmark. Both were internet-based questionnaires, and they both screened participants as being Swiss chocolate purchasers. Those participants were then split between test and control groups, the test group being shown the design, the Swiss Kiss mark, and the control group being shown the Swiss Wish mark. The test and control groups were then asked the same questions, including what company provides Swiss chocolate using the trademarks they were shown. Next slide, please. Hershey filed the Brigley survey, which, as I mentioned, followed many of the same design features as the Corbin and Bork survey, but omitted certain design flaws, such as issues revolving a priming bias in the questions, which I will discuss in a second. Similarly, they screened the participants as being chocolate purchasers and then split those participants between the test and control groups and asked them the same questions, including what company sells the brand of chocolate they were shown and what company sells chocolate under the Kiss and Kisses brands. Next slide, please. Before the court could consider the results of the survey in its confusion analysis, they first had to decide whether these surveys were admissible. And for a survey to be admissible in the court, it has to satisfy 4 criteria. First, the survey has to be relevant, which requires that it is both valid and reliable. The survey has to be necessary in assisting the trier of fact, in this case, the judge. There has to be an absence of any exclusionary rule justifying the exclusion of the surveys, and the surveys have to be provided by a properly qualified expert. Discussing the Corbin and Bork surveys first, the court found that they satisfied the necessity and properly qualified expert criteria, but failed at relevance and absence of any exclusionary rule, which I will now discuss. Next slide, please. With respect to relevance, the court found that the surveys were invalid for 3 reasons. First, the court found that the questions asked in the surveys were flawed because they repeatedly referred to Swiss chocolate, and this created a priming bias. By repeatedly referring to Swiss chocolate, it primed participants to think of Swiss chocolate brands and Swiss chocolate manufacturers rather than, for example, American chocolate brands such as Hershey. And the court found that this likely reduced the number of answers for Hershey in the survey, undermining the results of the survey as a whole. With respect to the second issue, the court found that these internet-based online surveys didn't provide necessary assurances that the screened participant is in fact who answered the questions attributed to them, and that they did so without any sort of external influence, such as a mobile phone. For in-person surveys, the court notes you screen the participants as being part of the relevant universe. So in this case, it was Swiss chocolate purchasers. And then because it's an in-person interview, the interviewer can see that the screened participant is actually answering the questions. Through the anonymity of the internet, however, there is no guarantee that the screened participant is also the person answering the questions. And the court found that without any sort of person in the loop or a video of the participant answering the questions, these surveys did not provide those assurances, undermining the validity of the survey. And lastly, the court notes that because these are internet-based surveys, the back button remained functional, and Dr. Corbin, the designer of the surveys, was unsure whether participants could use this to go back and further review the trademark. The legal test for confusion, which is what the survey is trying to measure, is the imperfect recollection of a consumer in a hurry. So normally in-person surveys, the surveyor or interviewer would show the participant the trademark briefly, take it out of view, and then allow the participant to answer questions in an attempt to simulate that imperfect recollection. However, because these surveys were designed to show the trademarks for only a handful of seconds and then move to a new web page where the questions would be asked, however, there is uncertainty whether they could simply use the back button to go back and further review the trademark. And if that's the case, the survey is no longer measuring what the legal test for confusion is measuring, the imperfect recollection. And so this uncertainty undermined the validity of the survey. Next slide, please. The second requirement for relevance is that the survey be reliable, and this largely refers to replicability. the court needs to be satisfied that if the same survey was given to a different group of people within that relevant universe, so Swiss chocolate purchasers, that the same results would occur. And the court found that those design flaws I just described call into question whether the same results would be reproduced in a subsequent survey. And Dr. Corbin also indicated that online panel surveys likely can't be statistically generalized to the broad population of the relevant universe because they consist of volunteers. So taken together, the court wasn't satisfied that these surveys were reliable either. Next slide, please. And lastly, with respect to the absence of any exclusionary rule, the court notes that surveys are generally an aggregate of hearsay opinions. So they're acceptable where they are relevant and properly designed and conducted. And the court said that to be properly designed and conducted, the surveys have to provide assurances that the participants personally provided the responses attributed to them and provided those responses in a controlled environment free from external influence. And as I discussed earlier, the court wasn't satisfied that the surveys did that. There was no person in the loop. There was no video of the participants answering the questions. So the court wasn't satisfied that these assurances were there. And so the court found that it did not overcome the exclusionary hearsay rule. And so ultimately, the court decided that all of PIM's surveys were inadmissible evidence. Next slide, please. Moving on to Hershey's survey, the Brigley survey. As I mentioned, it used many of the same design features as the Corbin and Bork surveys, but omitted certain design flaws that they identified. However, the court still found that it faced many of the same validity, reliability, and exclusionary rules issues, largely dealing with that inability to provide the assurances that the screen participant is who is actually answering the questions. So even though the back button and priming issues weren't as relevant for the Brigley survey, the court still found that the lack of assurances led to it being inadmissible. Hershey also conceded that their survey was designed as a response to the Corbin and Bork surveys, so it only would have been admissible had those prior surveys been admissible. So taken together, the court decided that this survey was inadmissible as well. So ultimately, all of the surveys were not found to be admissible, and after reviewing the remaining issues, the court dismissed the appeal. So ultimately, this case provides a little bit of guidance on how to design internet-based surveys and seems to indicate that when designing a survey, you have to be quite careful about how you design the questions, how you design the online implementation facing with that back button issue. And also, the court seemed to highlight that you need to hew as close as possible to in-person surveys, which might raise challenges for online surveys. But as I mentioned at the top, this case is under appeal. So the guidance it provides is subject to change. Next slide, please.
Thank you very much, Pelle. I'm going to hop in now and talk about this decision, Novartis AG and Biogen Inc. I'll start with a little bit of background. Novartis owns a registration for the trademark Beovu, which it uses in association with an antivascular endothelial growth factor, or anti-VEGF, biologic drug approved in Canada for treating neovascular age-related macular degeneration, which is commonly referred to as wet AMD. Anti-VEGF drugs are prescription drugs, specifically a liquid formulation injected into the eye by an ophthalmologist using a syringe. Health Canada issued a notice of compliance authorizing the respondents, Samsung and Biogen, to market anti-VEGF drug for treating wet AMD under the brand name Biovis. Now, you might disagree with the way that I'm pronouncing these trademarks, and I apologize if I am butchering them, but that will be a relevant factor in this decision that I will get to in a bit. So Novartis commenced an application in the federal court alleging infringement, passing off, and depreciation of goodwill. So with respect to trademark infringement, Justice Pallotta started off by identifying the relevant universe of consumers. She agreed with Novartis that in addition to physicians and pharmacists, patients are relevant consumers of anti-VEGF drugs. In particular, Justice Pallotta noted that patients have a choice to refuse administration, And this might be when they hear the name of the drug, when they are told by the ophthalmologist what will be administered, or when they're seeing it on the consent form that they are required to sign before being injected. And with respect to the attitude of these relevant consumers, Novartis argued that the high throughput, busy, stressful, and demanding nature of an ophthalmologist practice should be considered in assessing the likelihood of confusion. Justice Pallotta disagreed. In her view, ophthalmologists would not be more hurried, but they would instead be more likely to perceive small differences in drug names than the average consumer. And in terms of patients, Novartis argued that those being treated for wet AMD are a sensitive population. But Justice Pallotta again disagreed. She held that the evidence had failed to establish that patients would approach a decision about anti-VEGF drugs with reduced care or attention, or that they would be more likely to be confused because of their sensitive nature or their age. Justice Pallotta went on to consider each of the 5 factors enumerated in subsection 6.5 of the Canadian Trademarks Act and found Biovis to be confusing with Beovu, holding the respondents liable for trademark infringement. And 2 of those 5 factors were of particular interest in this case. First, inherent distinctiveness under paragraph 6.5a favored Novartis since Beovu is a coined term. The respondents had argued that distinctiveness should be a neutral factor because Biovis is also coined, and thus it shouldn't favor either party. But Justice Pallotta disagreed. According to Justice Pallotta, finding distinctiveness to be a neutral factor would undermine the principle that coined words are typically afforded a wider ambit of protection. With respect to the degree of resemblance under 6.5e, Justice Pallotta considered the uncertainty and variability regarding how the marks would be pronounced. There was no consensus in the evidence on how patients, ophthalmologists, or pharmacists would pronounce the trademarks. And this was held to further increase the likelihood of confusion. In this case, sound was a particularly important factor because it's a key way that consumers, and especially patients, encounter the trademarks. Next, Justice Pallotta went on to find the respondents liable for passing off. Health Canada had issued safety warnings about Novartis's Beovu anti-VEGF drug, which had resulted in negative publicity. Justice Pallotta found that the first element in the test for passing off, the existence of goodwill, had nevertheless been satisfied. While negative publicity might have reduced the goodwill in the Beovu trademark, it did not extinguish it entirely. And finally, with respect to the claim of depreciation of goodwill, Novartis was unsuccessful. Novartis did not establish a link, connection, or mental association between the Biovis and Beovu trademarks, and thus failed the first element in the test for depreciation of goodwill. Ultimately, the court granted Novartis a permanent injunction and awarded nominal damages in the amount of $20,000. The respondents have since appealed, and a hearing was in fact held on May 28, 2024, but the Court of Appeal has reserved its decision, so we are still waiting to hear how this one shakes out. And with that, I believe it's back to Pelle to discuss the next decision.
Thanks, Tierney. So the next case I'll be speaking about is Little Brown Box Pizza, LLC v. DJB. And this case is interesting because it provides a little bit of extra guidance on how to establish use with restaurant services, even where you don't have a restaurant in Canada. Next slide, please. By way of background, a Section 45 notice was issued to Little Brown Box Pizza, the owner of the Pieology trademark, and required them to show use of the Pieology trademark in Canada with all of its registered services within the last 3 years of the notice period. I've included the services on the slide there. It largely deals with pizza parlor and restaurant services. Importantly, Little Brown Box does not operate any restaurant locations in Canada. And after a hearing, the registrar expunged the trademark registration. Next slide, please. Little Brown Box appealed, and they argued that they used the Pieology trademark with restaurant services specifically in Canada in two ways. First, by advertising ancillary restaurant services to franchisees through a brochure and an online website portal designed to receive franchisee applications. The court was not convinced that this demonstrated use with restaurant services, and so this did not establish use. The second point is more interesting for our purposes. Little Brown Box argued that they provided ancillary restaurant services to consumers via the Pieology website and downloadable app. Next slide, please. So Little Brown Box provided evidence that they operated a website and mobile app targeted to consumers. They showed that several thousand unique Canadian users visited the website, and they showed that the website allowed consumers to review the menu, look up restaurant locations in the United States, pre-plan customized pizzas, save favorite pizzas for future ordering, and receive news about the latest product offerings. Next slide, please. They also cited two cases, TSA Stores Inc. and Dollar General. And both of these cases stand for the general idea that even where there's no physical location in Canada, no brick and mortar store, you can still establish use with retail store services through a website that Canadian consumers access that displays the trademark, and where the website provides a degree of interactivity and a benefit to Canadians that is similar or akin to visiting a brick and mortar location. So in TSA Stores, for example, the website featured a store locator function, allowing Canadian consumers to find the nearest TSA Stores location in the United States. And it also provided a gear finder and a shoe finder function, which provided a great deal of product information, allowing consumers to select products that meet their needs. And in that case, the court found that those information services was akin to speaking to a knowledgeable salesperson at a brick and mortar location, such that using the website was akin to visiting the brick and mortar location. And the court held similarly in Dollar General, where the website provided a great deal of product information. It provided online recipes and coupons, and also allowed Canadian consumers to purchase products. Importantly, though, the purchased products would not be shipped to Canada. It would only be shipped to an American address. And then Canadian consumers had to arrange for it to be shipped to Canada, such as through a transshipper. However, again, the court found that was enough interactivity and a benefit provided to Canadians to allow for retail store services in Canada to be shown. Next slide, please. So the court in this case had accepted that services, the concept of services, should be liberally understood, and that restaurant services don't necessarily require the operation of a restaurant in Canada. And citing those earlier cases, TSA Stores and Dollar General, the federal court found that the owner demonstrated use of the Pieology trademark in Canada in association with restaurant services because the trademark Pieology was displayed on the owner's website and mobile app, and the website and mobile app allowed Canadian consumers to customize pizza, and this provided a level of interaction and a service that was akin to visiting a brick and mortar Pieology restaurant, because the owner had shown and the court accepted that the build your own customization of pizzas was an integral part of the owner's business. And then the court also found that online advertising that the owner had conducted was targeted to Canadian consumers. So taken together, the court decided and found that they had established use of the Pieology trademark with restaurant services in Canada. Ultimately, the court did not find that they had shown use with any of the remaining services, so the court only maintained the registration, the Pieology trademark registration with restaurant services. So, as I mentioned, this case provides just a little bit more guidance on how you can establish use of a trademark in Canada through an interactive website, even if you don't have any sort of physical location in Canada. And that's it for this case.
Great. Thanks, Tierney and Pelle, for starting this off. I'm going to dive into two cases, one from the federal court and one from the provincial court, that look at injunctions, among other things. So the first case that I'm looking at is 51.ca versus Mr. Huang. And slide. Oh, I can't hit slide. Kwan has it. Okay. So this has interesting facts. And Mr. Huang filed for the for his application, the Chinese characters that you see on the screen before you, in 2006. And he received a registration in 2008. Fast forward to 2017, he filed an extension application, which was meant to have this, it's going to be the same trademark, but he's adding services to the application. The extension application registered in 2018. What's relevant to some of the analysis that I will go through is that the trademarks register in January of 2018 sent Mr. Huang a cancellation notice. So they requested that Mr. Huang provide evidence of use for the previous 3 years of the trademark in association with the services that were on the registration at the time. So while the extension application had been applied for, the services privy to the extension application were not privy to the cancellation proceeding. So by the end of the cancellation proceeding, the trademarks registrar determined that there wasn't sufficient evidence of use of the services as they were filed in 2006. And so they canceled those services. However, the services that were privy to the extension application remained, which meant that the registration was not expunged. So in comes 51.ca Inc. 51.ca Inc. has common law rights in trademarks that use the same Chinese characters in various composite marks. So 51.ca sought to strike the registration from the registrar and to prevent or enjoin or injunct the respondent from using the registered trademark in the future. I believe we are going on to the next slide, Kwan. So what's important, a key analysis point in this decision was whether 51.ca was barred by a limitation period. So Section 17.2 of the Trademarks Act states that a party cannot come forward and assert common law rights against a registrant with a registration older than 5 years, unless such common law rights were known to the registrant at the material date. So because this registration has interesting funky dates, we have the 2006 and the filing date of the original application, and then we have the 2017 filing date of the extension application. Because all of the goods or the services had been removed from the original application, even though the registration technically says 2008, the material date is 2017, which is the filing date of the extension application. So I don't expect all of you to follow everything that I just said there, but what's important to note is that material dates matter. And if there's an extension application, pay attention to what is privy to that extension application, because it might change what types of evidence is required. So, so the 2 dates. So what we're looking at is from 2017 to the start of this federal court application, which is 2022, which means that 51.ca is not barred by a limitation period. The registration isn't older than 5 years, and they were able to successfully bring this application and fight for the remedies that they were seeking to have. So does 51.ca establish that the registration should be struck from the registrar? Well, I'm not going to go into all of the nuanced details, but the important details for establishing whether it should be struck, or at least where the meatiest part of the conversation was whether the registrant was entitled to their registration at the material date. So the material date is 2017. And so we assess confusion from that date. So we can move to the next slide, Kwan. So the court is looking at, are the trademarks confusing as of 2017? First, the other side argued, so Mr. Huang, not Kwan, Mr. Huang argued that the applicant basically has admitted there is confusion because of what they submitted before the trademarks office. So the applicant is 51.ca, had filed a trademark application before the trademarks office, and the trademarks office opposed that application on the basis that its composite trademark was confusing with Mr. Huang's Chinese character trademark. 51.ca rebutted before the trademarks office and said, we're not confusing for the following reasons. We are in different classes of services. That was denied. The trademarks office still maintained that they were confusing. However, before the federal court deemed that this is not an admission of confusion for the purpose of this case. So the federal court went through the confusion analysis. For those familiar with the Trademarks Act, the confusion analysis is found, we use section 6.5 of the Trademarks Act, which is that the specific elements, including the similarity of the two trademarks. So do they resemble each other? In this case, the court found that the trademarks resembled each other. They were both, the prominent elements of the trademark were the identical Chinese characters. Then they look at whether there's inherent distinctiveness or acquired distinctiveness. Chinese characters aren't inherently distinct. So to find that you kind of want to have the balance weigh in your favor, you want to have more use in the marketplace. So in this case, 51.ca filed sufficient evidence before the court to establish it had used its mark in the marketplace between 2001 and the material date. Mr. Huang had filed no evidence. And in fact, 51.ca emphasized how much Mr. Huang had not filed any evidence of use. So the balance weighs in 51.ca's favor. They used it for longer, and they had more acquired distinctiveness. The court also reviewed whether or not the channels of trade overlapped, and found that both of them worked in the information and internet services industry, so the channels of trade overlapped. So we can move to the next slide, Kwan. So the applicant succeeded in getting the registration struck. The federal court found that there was confusion, and Mr. Huang was not entitled to his trademark. The applicant did not meet the test to receive an injunction. So this case did not go through a very thorough or deep analysis of injunctions, but the injunction that was sought here was a permanent injunction. And 51.ca had to show that the injunction was both necessary and appropriate. And the court simply said, it's not necessary because Mr. Huang isn't using the mark. And it's not appropriate because while 51.ca argued that Mr. Huang was uncooperative throughout the proceeding, his actions weren't tantamount to being wholly uncooperative. So they, I guess, succeeded in part on this decision. And it was interesting to see the federal court once again did not provide an injunction. It seems more difficult to receive an injunction in the federal court than it does in the provincial court. So we're going to move to the provincial court now. And that slide, Kwan. And in this case, we are looking at an interlocutory injunction, which is different than a permanent injunction. The interlocutory injunction is just an injunction that is in place while something else is, for a specific period of time, well, maybe something else is proceeding. So I'll go through the facts of this case to explain why it was an interlocutory injunction that was asked for. So the characters at issue here, or the parties at issue here, are Arc'teryx and Adidas. Arc'teryx operates retail stores and sells outdoor apparel and equipment, and has done so since around 1989. They were established in British Columbia, and so this case takes place in British Columbia. And if anyone knows, well, specifically Vancouver. So if anyone knows Vancouver very well, we are stationing ourselves on West 4th Avenue. where Arc'teryx has had a store since 2013. In 2022, Arc'teryx moved its store 2 blocks away from its original location, still bearing the Arc'teryx sign, and the new location was on West 4th Avenue. In January 2023, Teryx moved in onto West 4th Avenue, a couple blocks down from Arc'teryx. So Arc'teryx comes in and says that Teryx is infringing its trademark. It brought a claim before the BC Supreme Court, and that claim asserts, among a plethora of things, infringement, passing off, damage to goodwill, etc. We're not going to get into the meat of that because that civil claim is still ongoing. So while that civil claim is ongoing, Arc'teryx is saying, you know what, Teryx has to stop using this trademark until the court comes to a decision as to whether or not it's confusing. And I'll get into the details of why and the test that Arc'teryx had to meet in order to establish that Teryx may have to be enjoined from using the Teryx with the performance stripes. So the performance stripes in front of Teryx, Arc'teryx argues, kind of resemble the letter A. And Arc'teryx starts with the letter A and ends with Teryx. So it kind of looks like Adidas is saying, Teryx, and they're positioned 2 blocks away. And so they're kind of feeding off of our goodwill, and people are going to confuse us. So this decision goes through a really thorough review of the case law on interlocutory injunctions. So if that's something that you're interested in doing, or something that one of your clients are interested in doing, I'd recommend that you review this case. I'm not going to get into the full review because I don't have time, but it boils down to, we still have a 3-part test. The 3-part test is there a serious issue to be tried? Is there any possibility of irreparable harm? And where does the balance of convenience lie? So Arc'teryx says that the first part of the test, serious issue to be tried, is a low bar to meet. Obviously, Adidas disagrees that there's a higher bar and there isn't a serious issue to be tried. Well, Arc'teryx is in the right, and the serious issues to be tried are that there's possibility of infringement, passing off, and depreciation of goodwill. So the court says yes. The first part of the test is met very easily. There is a serious issue to be tried. So now, is there any irreparable harm? Kwan, we can move to the next slide. Well, Arc'teryx sets out that there is a possibility of irreparable harm because of unquantifiable potential losses. So if Teryx is able to keep its store on West 4th Avenue 2 blocks away, there's the potential that while the civil claim in the BC Supreme Court is ongoing, that Arc'teryx can lose some of its distinctiveness. There's also the possibility of what we call emotional brand equity. So there's the potential for loss of emotional brand equity, which we can't quantify that. So the court said, yes, there is the possibility of irreparable harm because these 2 things, either loss of distinctiveness, you cannot regain once it's lost, and loss of emotional brand, you can't quantify that. So now the third part of the test, where does the balance of convenience lay? Well, the court deemed that it's in favor of protecting the registered trademarks rights. So the court found that an interlocutory injunction is appropriate. However, they put limits on this injunction, and the limits are that the only store that the interlocutory injunction applies to is the West 4th Avenue store. So Arc'teryx has stores throughout 4 other stores in Vancouver, a bunch of other stores in BC, and a bunch of other stores across Canada. And the injunction doesn't apply to any of the cities. Like, say Teryx has a store that's up in Whistler. Teryx doesn't have to change that store, even if it's in the same town as an Arc'teryx store. It just has to change the West 4th Avenue store. As a side anecdote, when I was in Chamonix, France in October 2024, I saw a Teryx store and I was like, what? I wonder if they're going to try and sue Terex here too. There were no other Arc'teryx stores in Chamonix, France. France obviously has a completely different legal system. There were stores that sold Arc'teryx. So a part of me is wondering if the BC Supreme Court case is successful, will Arc'teryx go after Terex in general? But there's a huge backstory to the two of these trademarks, and they've been at it for a while, including a current ongoing opposition file. So I guess we'll see what happens. But I'll throw the baton back to Tierney, who will give you an update on trademark practice in Canada.
Thank you very much, Meika. Meika's right. I'm going to finish our presentation off today, wrapping up with 4 Canadian trademark practice updates from 2024. And first off, I'm going to start with everyone's favorite topic, which is delays in examination at the Canadian Intellectual Property Office, or CIPO. As you might know, there are 3 categories of trademark applications filed with CIPO. The first is Canadian designations of international registrations. The second is national applications containing only pre-approved goods and services selected from CIPO's Goods and Services Manual. And the third encompasses all other national applications, or in other words, applications that contain goods and services that are not specifically pre-approved. And the time from filing to examination depends on the category of the trademark application. And CIPO's current wait times for these 3 categories are shown on the slide. In June of 2024, CIPO revealed plans to substantially reduce the time to examination, including by hiring over 100 new examiners. At the time, CIPO hoped to reduce the delay to 24 months by March 2025. In other words, next month. And then earlier this month, CIPO made its forecasted wait times for first examination publicly available on its website. As of today, CIPO's website has not been updated for the month of February. It is still predicting that an application filed during the month of January 2025 will be examined within 13 months if it is either a Madrid designation or a national application containing only pre-approved goods and services, or within 15 months if it is a national application not containing only pre-approved goods and services. And this latter prediction is a very lofty goal, and it marks a significant reduction from the current 39-month wait time. Next up, we have our second update, which is the new specificity guidelines for goods and services. As many of you know, CIPO has one of the world's most stringent standards for assessing the specificity of goods and services described in trademark applications. In September, CIPO released new specificity guidelines to help navigate these requirements for describing goods and services by providing an indication of the level of specificity that CIPO requires. The information in the guidelines is listed according to NIS class and is presented in a fill-in-the-blank format, with explanations as to what needs to be specified. So as shown on the slide, an example is batteries in class 9, which must indicate either the specific area of use or the specific type of battery. The specificity guidelines also include a section titled Unclassifiable without further specification. So this lists terms that cannot be classified into the appropriate NIS class unless they are further specified. Another example shown on the slide is robots, which could fall into class 7, 9, or 10, depending on the specific type or purpose. Next up, our third update is on the pilot project for registrar-initiated non-use cancellation proceedings. So in general, non-use cancellation proceedings, CIPO issues what is called a Section 45 notice to the owner of the registration, requiring evidence that the owner prove that the trademark had been used in Canada within the 3-year period preceding the date of the notice. Previously, only third parties could request that CIPO issue a Section 45 notice. However, in 2019, the amendments to the Canadian Trademarks Act granted CIPO the power to issue those Section 45 notices unilaterally. Late last year, CIPO announced a pilot project in which it would start proactively issuing these Section 45 notices. In the first phase of the pilot project, CIPO will issue roughly 50 to 100 Section 45 notices each month to owners of randomly selected trademark registrations. And the first batch of these did in fact go out last month in January. In the second phase, CIPO will organize public consultations to gather feedback on whether these types of proceedings should continue, and if so, in what manner. It's worth noting that these CIPO-initiated cancellation proceedings will follow a special procedure that does differ slightly from the regular cancellation proceedings, and this is to ensure a more efficient and cost-effective process. And the purpose of this pilot project is to ensure that the Canadian Trademarks Register accurately reflects trademarks that are actually in use in Canada, or what is colloquially referred to as removing deadwood from the register. And finally, our last update for the presentation today is pre-assessment letters regarding unclassified registrations. Registrations that were issued before Canada adopted the NIS classification system on June 17th, 2019 must be classified prior to renewal. The Canadian Trademarks Office is now issuing pre-assessment letters that suggest acceptable NIS classifications for unclassified trademark registrations in cases where 3 criteria are satisfied. And the first is that the goods and services have not been grouped according to NIS classification. The second is that there is roughly 1 year until the renewal date. And the third is that CIPO considers the classification to be easy and non-challenging. And with that, it ends our formal presentation, and I will pass it back over to Kwan, who I believe is going to lead us through the question and answer period.
I think Kwan has accidentally left us, Tierney. So here, I think there's a question for Pelle. Why did the court find that surveys were necessary to assist the judge?
So the court cited the Supreme Court in a case which stated that surveys can provide empirical evidence demonstrating consumer reactions to trademarks and when measured against a control group, and it can answer certain questions that the trier of fact or the judge is trying to determine in a confusion analysis. And so it provides information that generally the judge would not know. And so on that basis, surveys can be considered necessary to assist the trier of fact. But the Supreme Court in that case did note that you still have to proceed with survey evidence with some degree of caution.
Awesome, thanks. And Tierney, regarding the pilot project, why does it matter if there's a bunch of deadwood on the registrar?
Thanks, Meika.
On the registrar, sorry, the registrar is a person.
Thanks, Meika. So if there are a large number of trademarks on the register that aren't actually in use, this makes it less efficient for businesses who are looking to create new brands or register new trademarks. Because a mark that is not in use but is still on the register, it can be identified as an obstacle during a pre-filing clearance search that a company might be conducting when they're creating a new brand, or it could be cited as a confusing during examination and when the mark might in fact not be in use, and this would cause that the owner of the application to either have to expend resources to argue to overcome the objection or themselves initiate cancellation proceedings.
Okay, so my apologies, everyone. My computer decided to randomly restart itself. I swear I didn't hit the restart button. So I apologize for that interruption, but coming back just in at the end here. Got one more question I can see here. Meika, I think this is for you. The question is why file in provincial court versus federal court?
Yeah, fun question. Sometimes often we grapple with that with our clients. And it depends on the remedy that you're seeking, and it depends on what claims you want to make in your statement, and it depends on your timeline. So, for example, if you file in the federal court, you can get a remedy that you can receive nationwide. The federal court applies across all of Canada. Provincial court, you only receive a provincial remedy. So in the case that I provided with Arc'teryx and Teryx, it's likely that Arc'teryx knew that they had a higher chance of achieving a local remedy because the issue at hand is quite local. It's in Vancouver. Then it may have achieved nationwide. So nationally, maybe they wouldn't have met the burdens to required to, or the tests required to meet to ask for the same remedies. As I mentioned, it's sometimes harder to get an interlocutory injunction in the federal court, and often easier to get that in the provincial court. And yeah, I think those are some of the biggest reasons. And then it goes into, do you want an application which is quicker versus a claim which might take more time, but you might have more access to different avenues of the statute? Do you have a statutory claim? Do you have a common law claim? You can do both statutory and common law in the provincial and the federal court. You just have to weigh the balance of what's important to what you want to achieve at the end.
Great, thanks, Meika. So I just noticed another question coming here. And this question, I believe, Tierney, is for you. Question is, please let us know if Canada's new pilot program in cancellation proceedings for non-use is triggered by a renewal filing, or if 3+-year-old registrations are just randomly selected.
It is the latter. It's not triggered by anything in particular, to my knowledge anyways. According to CIPO's information on the pilot project, it is just randomly selected registrations that are older than 3 years.
Great, thanks, Tierney. I think those are all the questions I'm seeing. So I know we've got 7 minutes left, but we'll give you that time and wrap things up for today. So thank you very much for your participation today and for the insightful questions that we received. As a reminder, when the webinar ends, a survey link will pop up on your screen. Please do take a moment to share your feedback. We do really appreciate it. Looking ahead, I believe the next year in review webinar we have, I believe it's on patent law. I believe it's next Tuesday, February the 11th. Same place, same time. So that's going to be noon Eastern, 9 a.m. For us here on the West Coast. And again, I just wanted to say thank you very much to everyone for joining us today, and we hope to see you at our future sessions.
Thank you.
Thank you.